You ready, sir?
I am ready.
All right. So today we have Greg DuPont from DuPont and Bloom and Steel. Greg is a seasoned lawyer with practice areas in estate planning and administration, probate, bankruptcy, and financial planning. He's a certified financial planner, and to me, I think he's pretty interesting individual because he has a holistic approach to his firm. Um, and I'd like to basically start off by saying thank you for joining us today in this podcast. And today's topic is going to be a very interesting one because it's going to be on estate planning, wills, trust as well. So obviously, with the pandemic out there going on, everybody is pretty much trying to figure things out as we take day by day. But I can say that confidently that Mr. DuPont has probably seen a little bit of action with this estate planning, especially now with the pandemic. And from a preparedness standpoint, I think we could just stop there and just say thank you for joining me, and then we could just jump right in.
You're welcome. I'm glad to have the opportunity to chat with you and talk to you about this oh so exciting topic, which is estate planning. So
Now,
I'll do my best to not run away your audience.
no, for sure. So before we jump into that, let's look at one part of your from your journey. If we look at your website, which is the law offices of DuPont and Bloom and Steel, there's a story on there that talks about a $1,500 experience that you had before, where you were working with a client and you saw that the client had was being billed at $1,500 rate. Can you shed some light into that? Because I think that may shape the audience's perspective of who you are as a lawyer today and what that experience shaped you to be the lawyer you are today.
Yeah. So yeah, that experience that we talk about is what was a transformative moment for me in my practice when I was involved in a will contest. And I was sitting there in a room out in Scottsdale, Arizona, one of my favorite places in the world. And I looked around the room and I realized that all the attorneys in that room, basically their accumulated rate was $1,500 an hour. And essentially, my client's family was paying for that because they did not have somebody that they trusted as an estate planner to be able to take care of changes that they needed to have changed when mom was getting older and was facing her demise.
Hmm.
And that is what led me to become holistic in the sense that I didn't want to have that ever happen to any of my clients where they ended up having to pay for a room of attorneys, all because their mom or their dad did not have anybody that they trusted to take care of things for them.
So you've been in this practice for basically roughly 2 decades now, right?
It's even more than that. I started practicing law with the focus on estate planning and probate essentially back in 1990 when I was still in law school. I started my first position as a law intern back then, and I've been focusing on those type of issues ever since
All right. So it's safe to assume that that has pretty much positioned you in today's world to basically look out for the client's best interest and not charge them astronomical rates like that. Which, if you do, that's obviously understandable for whatever reason that would be. But it's safe to assume that you look out for your client's best interest today, right?
then. Absolutely. So part of what I learned along the way is that there just were not. My practice is built around a holistic approach, and not only taking care of documents that are needed as part of an estate plan, but rather the entire picture in planning and building a long lasting relationship. And that's what was missing in that situation where the family was ending up paying that kind of money because they did not have anybody that they had a trusting relationship with. So that's kind of the lodestar of my practice now.
So when we look at the planning perspective through the lens of this pandemic or the lack of a pandemic, a planning, I'm thinking about preparedness, right? I'm thinking about to have a plan, you need to be prepared to tackle a problem. And in today's world, when we have families losing individuals because of the COVID-19, so a lot of folks out there may not have either a will, a trust, or a DNR, right? A do not resuscitate. Can you shed some light into the those three words? Because estate planning may mean a lot of things. So a lot of people may not understand the complexity or the simplicity of it. And I'm saying simplicity because it's not simple at all. There was a an article that I was reading that brought up Robert Stickhoff, which is a co-author of Wills, Trust, and Estates, and he says that every estate plan is a drama in human relations. And I found that so interesting because maybe you could also shed some light into that human relations as far as the drama that may be with estate planning.
Yeah, there's a lot to unpack there with what you just threw at me.
For sure,
So let's talk a little bit about first of all, what is estate planning?
for
Okay,
sure.
estate planning is essentially making sure that you have the tools in place to assure that your wishes are met when you are in the end of days, and that your wishes are met when you have passed away. Okay, those ones that are in place for taking care of those latter days when you're not able to speak on your own behalf are the living wills, the DNR, and the financial power of attorney that you referenced. The other ones, a will, trust, those kind of things take place after you passed away. And when we have estate planning conversations, many times you do get into those dramas that you referenced because um, I've seen it too many times over the years when somebody, the matriarch or patriarch, has kind of been keeping their thumb on things with a bunch of brewing problems below.
Hmm.
Once they're gone, then all those type of problems start coming to the surface. And so a properly prepared estate plan does what can be done to keep the type of simmering feuds still under control.
Now, is it because I know we have some legal solutions out there on the web that anybody could just go out there and do it for free. To me, I see that as a risk. Where if you go out there and try to do your own, and I'm not going to name any names out there, but what's the risk if you actually do end up not utilizing a lawyer?
So first of all, most of the services that you find out there on the internet, they prepare documents that are perfectly valid and enforceable. They're very careful to set things up that way.
Hmm.
The problem with those type of processes is that they lack the nuance that comes from working with an experienced attorney. And first of all, it's difficult enough to get people to finish up anything. Okay, but when you're dealing with death and dying, if you don't have those documents done and completed absolutely correctly, then they're worthless. So you may have filled out a will on XYZ website and not signed it, not had it done the right way according to your jurisdiction.
Hmm.
And then you end up causing problems when there perhaps were none,
Hmm.
because you've now created an ineffective document that can be litigated. So again, although they're can be valid and they're okay, you only have one time in your life typically to deal with wills and things like that. So let's do it the right way.
And what's the is there a certain time that people should be considering actually getting one done? In your experience, when is the right time or the wrong time to actually start one?
Somewhere between becoming an adult and dying.
Okay. That's pretty broad. So it's a cycle, right? It's a human cycle.
That's right. Yeah. Any time after you become an adult, there is a valid reason to have a will done, a financial power of attorney done, a healthcare power of attorney, living will. There's value to it at all points in life. So for example, many times when people are going off to college, their family will come in to me and have those documents done for them because they now realize that the kids are adults, and because of HIPAA laws, nobody can talk to the medical professionals on their behalf anymore.
Hmm.
So they need to have some of these will type documents, the living will specifically, the power of attorney for healthcare, so that somebody's there to be able to help them. And so there's really no time that's too early nor too late after you become an adult. Now, obviously, the other end of the spectrum, when you die, or before you die, that's when we have even greater need for that, right? Because now the end is near and it's apparent, and we need to make sure that our wishes are taken care of.
Hmm.
So, short of those two extremes, typically when people come in to see me, they come in to see me when they've had their first kid, or they've had something going on in their world where they've been triggered and they're very aware of this. Like now with the COVID, when my phone's been basically ringing off the hook with people that want to talk to me and get their affairs in order.
So compared to last year, how much increase of an increase have you seen on in your business?
You know, The week before we had the shutdown, I did more wills in that week than I would do in a 2-month period in the prior year,
Wow.
and I do a pretty good number of wills.
So
Yes.
from that, and we're talking about in the state of Ohio, right? So in
Yeah.
the state of Ohio, we've been in a, what is it, week four now, week eight, probably.
Well,
It's
we've
hard to
lost
keep
track of
track,
it,
huh?
haven't we? We've all lost track. It's Groundhog Day. Bill Murray. Each day we wake up and it's a different thing. So that was specifically in the first week of March when I had hit that type of number.
Yeah, because I have seen some news articles that people that essentially in lawyers in your field have seen an uptick, right? Which is completely understandable. So basically, every single change in the life cycle that you see, like you said, from adulthood, you have a child. It's actually important to actually get these documents done. But there's a right way of doing it and a wrong way of doing it. What are the things that individuals should be considering to get in order before they actually go to you, or should they just go and have a conversation and then you'll give them the marching orders?
So the way our particular process works is once they've made a decision they want to have a conversation, we walk them through the process from beginning to end. We send them now because of COVID. We have virtual meetings to start things off with. Where prior to that, they will receive a detailed questionnaire that then drives our conversation.
Are there three or four things that people should be considering as far as financial things that they should be getting in order, like their finances for you or their assets? What are the common themes in that questionnaire?
Um, the thing that people need to understand is there's a difference between documents, what assets that documents like wills deal with, and what their estate, broadly speaking, is. Okay.
Hmm.
And for younger people, you ask kind of the phases. For younger people, most of their assets are their retirement plan that they have at work, and maybe some form of group life insurance that they have at work, and maybe a home. Okay, but with assets like a retirement plan or a group life program, they have beneficiary designations. And that's all that's needed to make sure that those assets, if you pass away, go to where they need to go.
Now, are there any financial implications involved with this at all if it's done correctly or incorrectly?
Yes, depending. Okay.
Hmm.
The biggest mistake that I see people make is with retirement plans, those type of things, not having a beneficiary named on it. Then now, because there's not a named beneficiary on that, then those go through the estate, and that causes immediate taxation of those assets, as opposed to having some opportunity to defer the taxation over years. But other than that type of situation, assets typically for an estate, at least here in Ohio, where we have no estate tax, and on the federal level, where the estate tax doesn't kick in until well over $10 million, there are really no tax implications.
Now, is that when you say estate, is that the probate process?
So that is the combination of all assets in your name upon your death and insurance to determine what is your taxable estate. The probate process only speaks to those assets that are in your name and your name alone at the time that you pass away.
Now, what kind of so you spoke about the beneficiaries would be one of the biggest mistakes that you have seen within the course of your career. Are there any other opportunities that people should be considering? Because I know part of the process when you're filling out a 401k or whatever, they actually ask you who would you want to be as a beneficiary. But why would people not put that? Is there a rationale or rhyme or reason?
Uh, Oversight, typically. You know, yeah, I had a case a couple of years ago where the beneficiary that was named in there had died well before the person that I was administrating the estate of had died. And because that beneficiary had passed away, then by the document that controlled that 401k, then that now gets paid to the estate. And so it goes through that process. So it's those type of things. People tend to set it and forget it with their beneficiaries, and it's a good practice to periodically contact those institutions that you've done that with, and have them verify for you uh, who your beneficiary currently is. Because as people change through life, you start your first job, maybe you've named your mom or your dad as that because you're not married at that point in time.
Gotcha.
and you just forget about it.
So it may be a thing that it may be a situation where you have actually have appointed somebody at some point, but you just, like you said, you set it, forget it. Now you're 10 years afterwards, your parents may not be there, and now who does it belong to?
Right.
Now, how does that in the court system? How does that get resolved? And that's probably a loaded question in itself. As far as now, you have that individual, your former client, or individual that has passed. They don't have a will or trust. How messy does that really get? And I think that goes back to that quote that I mentioned from Mr. Stickhoff over there. How messy does it truly get when it starts to get into the court system?
The messiness starts with the family itself.
Okay.
Okay? So, over the years of my practice, I've had people fight over the silliest things. Okay, and it's again, as Mr. Stickhoff says, the dramas of human relations. Um, Once that person that's been keeping people in check is gone, then all those long-held animosities just bubble to the surface. And the probate process, just like the domestic relations and divorce process, that's where if people have ill will toward each other, they have the opportunity to create all kinds of havoc without we don't have the right documents in place.
Do you have any examples that you could share without releasing too much information?
Well, I've had clients over the years that have thousands of dollars of legal fees on fighting over things like riding lawnmowers,
Okay.
that are barely operable. I had a situation a couple of years ago where uh, family, a second spouse situation where kids from the prior marriage, thought that the decades old tools were worth tens of thousands of dollars and
Okay.
caused tens of thousands of dollars of damage with legal fees to find out that they were in fact worth nothing. Okay, so those are the type of things that are out there, and without even going to soap opera topics where we have kids that were estranged from prior marriages and those kind of things that come out of the woodwork. So, but
Hmm.
very basic, you're dealing with human emotion, and sometimes the rational value of things has no relation to the emotional value of things.
Now, have you dealt with individuals that have assets outside of the United States as well? So, an individual could have an Ohio address or Ohio assets, but they also have assets across, out of the United States, across the pond, or down in South America, wherever it is. How did you manage that scenario?
So the assets across the pond or where have you, they're going to be dealt with there. I have lots of clients that are Indian, and
Okay.
they have lots of assets back home as well as what they've got here. So the estate plans that we set up here, if someone were to die, they would have their primary estate administered here, but then those documents that we prepared here would end up being sent overseas, essentially, to administer those assets over there.
So there is some type of synergy with now. Which documents are primary then? In that situation, with the American or the Indian? How would that work?
So there's really like one document, right? The will,
Okay.
or
Okay.
one document, the trust,
Okay.
and that gets its legal impact in the probate court where the person died. Okay, so Delaware County resident has property in India, well, and property here in Delaware County. Their probate estate is established initially here in Delaware County. And then the courts from Delaware County and the courts back in India coordinate on those documents that have been proven to be the legal, effective, binding documents here in Ohio to then whomever is taking care of their affairs in India uses those as their guide stone care of that there.
That's pretty interesting. I've never even. I mean, that was a question that I had here prepared for you, but there's one document, and that one document pretty much is a driving force here in Ohio and wherever else. I know you mentioned India, but that could be also anywhere else around the world, correct?
That's correct. Yeah.
Now, are there any advantages as far as having one or the other, as far as the will trust, or do they all should be in one package?
So without getting too deep in the weeds,
Yep.
typically um, a will is something that is deals with the directive of those assets that are in your name upon your death, the probate assets.
Hmm.
Typically, a will is used in conjunction with the trust. Okay, and the trust, the difference is the trust controls only those assets that belong to the trust. Okay, so it's possible to have assets that are managed by a trust and then assets that are not even part of the trust. Okay, and so when we use a will in conjunction with the trust, typically what the will does is directs things into the trust. So at that point in time, those assets are all managed by the trust there.
Hmm.
The will is directly in the court. The trust does not necessarily need to be in the court.
So you did mention you don't want to get too deep in the weeds, but I'm assuming you could take those comments and that thought process a little bit further. What are those? What are those
I can
things?
get real deep in the weeds if we want to put your audience to sleep here.
A little. If you could dig a little bit deeper there,
Sure, certainly. So you're asking a lawyer to talk.
let's do it.
So the will again is the primary document to direct what happens when you pass away. It's
Hmm.
going to set up the structure for the assets that are subject to probate administration. We mentioned things like your retirement accounts and insurance. Well, those aren't necessarily subject to estate administration unless you have made the estate the beneficiary. Okay, but the will is going to be what the law looks to put somebody in charge of your estate. That person is who we call the executor, and it's going to give them instructions on what to do with the assets in the probate estate, which could be give all of my stuff to my kids, and then it's over and done when that executor reports back to court that they've done it. Or the will could say, put my assets into my trust, and so now at that point in time, the trust takes over with the management of the assets for whomever are the beneficiaries of the trust. So typically, we look at kind of the will is for, at least in modern plans, the will is for a short duration, settle your affairs, and the trust is there to manage assets for a longer period of time. Either a period of time that starts when you pass away and the assets come to it through the trust, or in many situations throughout your life, people have trusts where they put their assets into it at that point in time to gain some form of efficiency or other benefit to manage your assets through that trust during their lifetime.
Short term, long term perspective, right? Like you mentioned there. Now I can see how person A, John Smith or Mrs. Smith, and now unfortunately something happens to them, and now who somebody has to enforce this. And as far as their wishes are documented on these documents, but who's the one that actually enforces these? Because obviously you and your team have been the individuals that have prepared this strategy as far as after death strategy, but who's the one that actually enforces it? Because you have the state coming in. Is it the law enforcement? Is it who would be that individual to enforce that?
The person that enforces it is the person that you have named in your will as your executor.
The executor. Yep.
Yeah.
Hmm.
And they, by virtue of the will giving them that authorization, they go to the probate court, here in Ohio is what we call it, to be appointed officially as that executor. And then that gives them the legal authorization to manage your affairs when you passed away.
That seems pretty simple enough, right? When you say, "Hey, I want Mister Smith over there to be the executor," but that could also get messy and complicated, can it?
Absolutely, especially when you're dealing with second marriages and those type of things. That now we've got again those simmering problems from before
Yeah.
that can come to the surface, and the kids that didn't like mom, the new spouse, then they can cause problems that way.
Do you have any examples from that perspective at all from your experiences?
Oh yeah. That's when you start having the allegations that step monster is hiding monies, those type of things,
Yeah.
uh, or that that was the context of the $1,500 an hour type of thing.
Hmm.
That when we don't have a good plan in place, then those type of things can definitely bubble up. So typically it does, or come out of um, disenchanted children, either from some fractured nature of a family, uh, that is the nuclear family, or prior families and prior kids from prior relationships that feel like they're being mistreated.
Now, let's say there is somebody who's listening to this podcast and has considered doing this, but just says, you know what, this is not for me. I don't have the time to do that. And I just want to shed some light on Prince, right, the artist, where as we all know, Prince passed away, and he didn't have a will or trust. Now you have this individual with all this music out there, all this asset. Uh, have you ever seen a situation like that in your experience or in the state of Ohio, where you had an individual not quite as rich and famous as he was, but maybe with all those assets that we're talking about here, and a situation like that happens? What is the next step for an individual like yourself, a lawyer, that they say, "Hey, I need some help here"?
So, if there is no will in place, then we have a handful of laws that control what happens, but give us a lot of uh, they don't give us a lot of latitude on things. Okay, so
Us meaning
the
the state.
estate, the executor, the system. Okay, so we end up in a situation where we are proceeding in the dark. Again, think about the Prince situation. At least Prince had business managers that knew what records he had, what songs he had copyrights to, and all those kind of things. As messy as that situation was, well, I've dealt personally with estates where people have had bank accounts in different places in Ohio, and there is no evidence of where those things are, and so we have to go looking for them.
Hmm.
And so we end up with just many man hours trying to find those assets. So it's very important that above and beyond having the documents in place for estate planning, that every once in a while you make some note about where your stuff is, so that if somebody else from the outside has to come in and take care of things, then they have benefit. I only, we kind of jokingly talked about between 18 and death. One of the most messy estates I've done the last 3 years was a 24-year-old that has, started accumulating some assets, had no will, and had nobody that was really there to help them through things. So there was a lot of unknowns, and we had to dig a bunch of stuff out.
Hmm.
So it's never too early to have these type of plans in place.
Now, how about digital footprints? Is that part of your? We've had this conversation back in the 70s and 80s. Probably digital would not be part of the questioning or the conversation. Since you spoke about that 24-year-old experience, obviously now social media is huge. People are texting back and forth. There's a footprint there. No matter how you slice it, there's a footprint there in conversations and transactions, documents that are shared back and forth in the dark, meaning that only me and the individual. Now I'm not there anymore. Is that part of your focus as well right now?
It's increasingly becoming part of the focus, because one thing you notably didn't reference there was your X gigabyte terabytes of pictures, right?
On your
All the,
personal computer?
yeah, or just out in the cloud. Yeah, all of that history, or you're what's going to be interesting as we continue on down the road is things like your record, what used to be a record collection, now being digital audio, or
Hmm.
video collection, which now is digital video, which by many of the licensing agreements you never really own them, right?
Okay. Yeah.
But those type of things are increasingly becoming a challenge for estate planning, and not all states have a good setup for that yet, in terms of even authorizing in a manner that the service providers will allow access to the histories.
So, is there any guideline right now in the state of Ohio or in the U.S.? I know you mentioned that a lot of times there may not be, but is there any particular protocol or guideline for how to handle that at all?
So, not yet, really. I mean, there was a law passed that tried to deal with it, but I don't think it's very effective. So in Ohio, the best thing to do is make sure that somebody somewhere knows the master password or whatever to be able to get at those assets, or you've otherwise left that in some format that if you did pass away, that can be accessed, so that you can get in before it gets shut down.
You know, on Facebook, I saw a couple days ago, somebody posted on there that they saw a post from a certain individual that passed away, and that individual said their goodbyes within 5 hours. And I sat there before our meeting today, and I was thinking about exactly what we're talking about here. Okay, then you have that individual that passed. Facebook, right? So Facebook, they may, like you said, they may own all this content, all this data of this individual. And my question was, who's going to manage that? Because that password could be as simple as your home address, or people put their zip codes or something like that, or something as encrypted as a pretty strong password. But like you said, if you don't have the password, that could be a challenge in itself. And I know for sure Apple does not release the customers' data at all, even to the federal government, right? So what's to say that they're going to share it with your office, because the wife or the husband or whoever requires to get in there and get access to their bank account information and so on and so forth.
Yeah,
So that could be a messy road as well. And
absolutely.
hopefully there's a solution coming down the pipeline later on.
We keep working on it. But for now, we try the best we can, and it's a complicated blend of state and federal law that needs to be kind of figured out.
So is that part of your questionnaire at the moment, as far as the digital footprint at all?
Not yet, not yet.
Yeah.
Most of the people that come in still are a little bit older than that.
Okay. So as far as your clientele, who do you have time right now, or do you have room to get any more clientele in the pipeline? Because I know, like I said before, your phone is ringing off the hook now. But do you need is what is the perfect client for you right now? I guess
First of all, there's always room. We've got processes in place to always make room for
for sure.
may not be as timely as it would otherwise be, but typically our process is over and done in a couple weeks.
Hmm.
And we've streamlined things really well so that we're able to handle quite a volume, at least as within reason, right?
Hmm.
Um, the typical clientele, though, is a family with a young kid. That's really when we first see people, get to know them. And then we go on down the spectrum, and then the next level of people are starting to get worried about long-term care and those type of expenses and those real difficult estate planning issues that come on down. After you get on the other side of that adventure called life.
So how can an individual reach out to you? I know the your website is
Best way to do it is, yeah, just to shoot out to www.dandblaw.com. They can schedule an appointment directly off of the website, or they can give us a call at 614-408-0529.
perfect.
614-408-0529. We're standing by.
Now, are there any questions that I have not asked that you think will be beneficial for individuals to hear?
What we haven't talked about, which I think is appropriate for people to just to kind of get a base understanding, because I've heard over the years too many times people kind of confuse some of these documents.
Mhm.
And I do have a series of videos that are available if people want to walk through them, but understand what a living will is. And it's very important. That's the one that I said that as soon as you're 18, you really should get one. What the living will does is that establishes what your wishes are with regard to your care if you're in a terminal condition or a permanently unconscious state, essentially affirming that you do or do not want the hospital to continue to provide care if you have been diagnosed terminal and the end is imminent, and if you're in a permanently unconscious state, whether or not to be provided nutrition, and see what happens if you are in that unconscious state.
Mhm.
That document works hand in hand with the healthcare power of attorney, which is your appointment as somebody to be your advocate with regard to your care. So that is something that, regardless of where you come down on your decision for those issues, it's very important that you have that done so that there is no uncertainty, because uncertainty in that area can drain the family of resources and uh, just the sheer emotion tied to those decisions that really needs to be taken care of.
It's all about preparedness, right?
Yep, yep. And then we talked about what a will is, what that does, and how that controls things, and trust and those type of things. So those are your cornerstone documents. But estate planning, as you mentioned, it does touch on all kinds of emotional issues sometimes, uh,
Hmm.
and that's what you really can't deal with through a online provider typically, because they don't nuance those type of issues. So if you got any of those type of things simmering below the surface, you're doing yourself and the family a disservice if you use one of those type of systems, because the chances are that you're going to do something wrong,
Hmm.
which is going to now allow all those simmering fights to have a place to kind of bear fruit.
And I probably should have mentioned this before. Full disclosure: I have personally used your services in the past, so you're a pretty solid lawyer. So I appreciate that, my friend. All right, so this is again Luis Ramirez with Greg Dupont from Dupont and Bloom and Steel. Thank you so much, Greg, for being on the show, and I appreciate you.
Thank you, Louise. Take care.